Hello, everyone, and welcome to the second panel for today's Refugee Law Conference. This is the panel titled Refugee Law and Politics. I'm Cory Rodgers, and I'm from the University of Oxford's Refugee Studies Center, and I'll be moderating this panel. So the idea of the panel is that there's an observation, which is that politics can shape refugee law and policy in a number of ways. Legal scholars, though, often appear reluctant to participate in the emerging debates in the political science about the ways that this plays out in practice. In part, this may be due to the underdeveloped doctrinal understanding of refugee law and policy that is sometimes on display in such political science analyses. By contrast, this panel draws on insights from both the legal and the political science fields to offer fresh assessments of the politics of refugee policy. So as you've heard previously, our speakers today will start us off by presenting some key perspectives on, in this case, three quite different components of this issue, after which we'll open up for broader discussion, and I welcome you to send your questions through the chat function. Each of the speakers will have 10, or because one of our speakers has dropped out, maybe a few more minutes, and I'll be enforcing that time limit, let's say with a cap at around 13, 14, or 15 minutes. I would remind you all to please keep your microphones on mute and your videos off unless you are presenting, and then we can all come back together for the discussion at the end. So without further ado, I would now introduce Natasha Yacoub from University of New South Wales Law in Australia, who will be presenting on gendering the criteria for the return of refugee women, a focus on Darfur. So over to you, Natasha.
Thank you very much, Cory. I'm speaking to you today from the Ngunnawal land, and I'd like to start by recognising the traditional Indigenous owners of this land and their elders past, present and emerging. I recognise that this land was never ceded and that the quest for justice is related to some of the issues that I will be talking about today. So now to begin. Is the 1951 Refugee Convention aging gracefully at age 70? I would argue that she is just hitting puberty, a time when the body of law is in a state of transformation and destined to mature. A dynamic interpretation of the convention that better incorporates women's rights will enable this maturing to take place. Feminist legal theory provides an opportunity for both observation of laws and policies failing women, as well as an aspiration for a system that better protects them. It has already made great contributions to international refugee law, notably arguing for the inclusion of women's experiences in defining who is a refugee. I will use the example of voluntary repatriation of refugee women to Darfur to demonstrate how further maturing can take place. I will explain in my presentation the ways that the Convention can better protect refugee women from Darfur upon voluntary repatriation. First, with respect to the duties of the country of asylum. Second, with regard to the country of origin. And finally, exploring the role of third countries. So why the focus on Sudan? The voluntary repatriation of large numbers of refugee women to Darfur is in the planning stage. Women played an important role in the revolution of December 2018 that saw the ousting of President Omar al-Bashir, who'd been in power since 1989, and the installation of a civilian military government and transitional constitution. The return of displaced persons to Darfur is high on the agenda for any new government, with almost 2 million internally displaced persons and at least 1 million refugees, many of whom are women. Another reason to focus on the Sudan is that gender-based violence was a key driver of displacement. The former government has been prosecuted by the International Criminal Court for the crime of genocide and other crimes, including rape. In addition to violence as a result of war, women fled institutional and structural violence. For example, Sudan's public order laws targeted women with flogging or detention for what they wear or how they conduct themselves in public. And a final reason to focus on the Sudan is that women's rights continue to be sidelined in the current transition process. Although the Sudan signed in recent weeks, the Convention on the Elimination of All Forms of Discrimination Against Women, women have not been meaningfully represented in the transitional government or the peace process, with the result that their rights are often ignored. In the absence of clear progress of the government to address the harm that caused women to flee, they risk being returned to the violence that they fled. And history has shown, as I've heard coming up on some of the other panels, that voluntary repatriation operations can otherwise be dominated by state interests instead of protection, including political pressure from asylum countries for refugees to return. So what can be done about it? First, I'll look at the obligations of the countries of asylum. Refugee law scholars and UNHCR explain that the obligations of the country of asylum in voluntary repatriation is governed by the provisions of the 1951 Refugee Convention, interpreted together with international human rights law. The main legal principles governing the return of refugees are the prohibition of refoulement in Article 33, requiring a state not to send refugees back to a place where their life or freedom is threatened, and the cessation clauses in Article 1C, 4 and 5, providing for an end to refugee status owing to a fundamental change of circumstances in the country of origin. The interpretation of these laws by the country of asylum and others should not ignore women's experiences. Feminist legal theorists explain that international human rights law privileges the experiences of men and ignores those of women often. Alice Edwards states that the reason for this exclusion is structural as well as formal inequality, the causes for which are patriarchy, exclusion and oppression, combined with poverty, harmful or discriminatory cultural and religious practices, and political disenfranchisement. A dynamic interpretation of international refugee law that includes women's rights can, however, address this. If women are to return to Darfur in coming years, they cannot be returned by the country of asylum to a situation where they continue to fear a loss of life or liberty on account of their gender. In Sudan, for example, where rape is committed inside or outside the home with impunity, and when women can be prosecuted for adultery when reporting rape, the situation causing women to flee is not being resolved. If the 1951 Refugee Convention fails to account for the rights of women, and they risk being returned to violence. Second, obligations of the country of origin. There is no substantive provision explaining the obligations of the country of origin in the context of voluntary repatriation in the 1951 Refugee Convention. This is in contrast to Article 5 of the 1969 Organization of African Unity Convention that explains the obligations of the country of asylum and origin in this context. Rather, the criteria for voluntary repatriation in international refugee law are to be found in guidance of UNHCR and conclusions of the Executive Committee of the High Commissioner's Programme. In the UNHCR handbooks on voluntary repatriation of 1996 and 2004, the criteria for a return in safety and dignity are spelled out, and there are some references to women's rights. Complementing this guidance, the Executive Committee as a group of states provides an authoritative interpretation of the criteria governing voluntary repatriation, often drawing on international human rights law. In a review of all conclusions between 1975 and 2020, I found that the committee made reference to voluntary repatriation and gender in 7 of its conclusions, setting out how women should be protected and referencing international human rights law. Although these documents may influence the development of international refugee law, they are not, strictly speaking, legally binding on states outside of their existing international human rights law obligations. Feminist legal theory scholars approach international human rights law with caution. In a provocative statement, Catherine McKinnon stated that human rights in the general sense are not women's rights, not in theory, not legally or socially, not domestically or internationally. Where international human rights instruments do specifically protect women's rights, Hilary Charlesworth and Christine Schinken argue that they carry less legal value. So to carry more weight, protections for women in the voluntary repatriation process must be prioritised as binding obligations of international law. This could be done through an optional protocol on durable solutions in the 1951 Refugee Convention, and the obligation to protect women on return could be framed as part of a general international law obligation of the state to protect its citizens, at a minimum from mass atrocity crimes, and redress for the bond that was broken when women fled the country. This means that the government of the Sudan would be responsible to change discriminatory laws, practices, and views leading to ongoing harm and destitution of women in the country. For example, reform of land law and practices should enable land rights for women and therefore independent livelihoods. They should be compensated for past wrongs, such as land appropriation, leading to what Megan Bradley persuasively argues would be a just return. Now, finally, I wanted to look at the obligations of third states. The 1951 Refugee Convention does not oblige third states to cooperate to find durable solutions for refugees. The imperative for third states to find solutions has been reinforced by states in the Comprehensive Refugee Response Framework stemming from the New York Declaration of 2016 that's been discussed quite extensively in other panels. If there are limited opportunities for women to integrate locally or find durable solutions in third countries, a return to violence may be the only option. And this repatriation should not be considered voluntary, nor should it be considered a durable solution. Feminist theory offers a useful lens to understand the responsibility of third states to find solutions for women other than a return to the Sudan. Carol Gilligan's approach to international law using an ethics of care perspective breaks down distinctions between citizens and non-citizens. It provides a moral and legal imperative for third states to share responsibility. It provides a humanitarian basis for states with capacity, especially in the global north, to find solutions beyond what is presently available, that is, resettlement places for less than 0.5% of the world's refugees at present. This draws on the good practice of an ethics of care approach to resettlement in New Zealand, where places are offered to individuals harmed by Australia's offshore processing practices based on humanitarian imperatives and not political and legal categories. Women from Darfur have been displaced for up to 2 decades in neighbouring countries. Many have continued to experience violence and conflict in the places they have sought refuge, with the largest populations in Chad and South Sudan. They further risk harm if returned to the Sudan, where their needs for healthcare and otherwise cannot be met. Third countries, especially those in the global north, could offer resettlement and other options to these women. And in addition to this, integration could be made available in countries of asylum, such as Egypt, where women have made significant connections within their community. Only when women have choices can voluntary repatriation be truly voluntary in these instances. And now to conclude, in coming of age, the 1951 Refugee Convention has the potential to mature. I've set out the ways that in the context of the return of refugee women to Darfur, the countries of origin and asylum, as well as third countries, can do better to protect them. When the 1951 Refugee Convention is interpreted in a dynamic way to include the rights of women, it will have matured. In doing so, it will set itself apart from the system of oppression harming women. And otherwise, it risks being one with it. Thank you very much, and I look forward to our discussion.
Thank you, Natasha. Thank you for that, a very an interesting talk that provides some solutions as well for ways forward, and also a useful metaphor, the idea of the Refugee Convention is at puberty. So I appreciate that, very much in line with the conference theme. So now we'll be turning over to our second presenter, who is Mark Symes. And Mark is coming to us from the Garden Court Chambers in the United Kingdom. And Mark will be presenting on UK refugee law post-Brexit. Over to you, Mark.
Thanks very much for the introduction. Yeah. So my talk is intended to fit into this session because it touches very much on the interface between refugee law and politics. So I'm going to rather concentrate on the law end of that discussion. But the Brexit decision in the United Kingdom has huge implications on all aspects of UK law, including refugee law. And of course, this is an area in which the national strategy was to take back control of various aspects of our law and to take back control over our borders. I'm just going to now aim to screen share, which I must admit I didn't actually rehearse this earlier, but I'm quite hopeful it's going to work nevertheless. Yeah, here are my slides. I think that seems to have come up okay. So here we are on this slide now. You can see the main aspects of refugee law which Brexit will impact on. And these are perhaps the three of the primary aspects of refugee law in the first place. There are procedures, including removals to third countries. Third countries has always been a politically controversial aspect of refugee law. Reception conditions in the UK, and then substantive refugee law. And all this is likely to be significantly impacted by Brexit, because those legal regimes have been controlled very largely by EU law in recent years. So as listed on screen now, you can see the Qualification Directive, the Procedures Directive, and the Reception Directive. To some degree, these provisions, these directives, have been transposed into UK law, not entirely, but very largely. They're found in aspects of the immigration rules, and also they're found in aspects of the domestic regulations, like the refugee regulations, which largely define who is a refugee. And also there's reception conditions regulations. All these instruments were passed back in 2006 or 2007. And the reception regulations talk about the duties to provide minimum subsistence and to trace family members of asylum-seeking children, for example. So there's no doubt that quite a lot of our body of refugee law in recent years has been EU law. And the question is really now, to what extent will that be part of EU retained law in the future? So what we see about this is that going forwards now, there are going to be essentially three routes into UK law by which old EU law maintains its effect. And that's either because it's EU-derived domestic legislation, like the examples I just gave, because our rules and regulations often transpose EU law, or because it's direct EU legislation, like the Dublin III regulation, I suppose, or because there are directly effective rights. Now, the strategy of the political and legal strategy of the government regarding those three routes of conversion of EU law into domestic law has been to shut things down as much as possible for anything that touches on immigration at all. So although in most areas of law, like competition and regulatory stuff, Section 2, 3 and 4 will each be a source of future obligations, Sections 3 and 4 have been almost entirely shut out in the UK's transposition. Some suggestion to the contrary by the Supreme Court a few weeks ago in the case of G, though whether or not, I'm not entirely sure the Supreme Court were completely on top of this very complicated legislative arena. So, as you can see on the screen now, the second bullet point, basically there's this very strong norm in the UK legislation now that EU-derived rights won't be recognised if capable of affecting the interpretation, application or operation of the Immigration Acts. So it's only really going to be the stuff that's already enshrined in our local legislation, the regulations and the rules, which are going to be retained EU law. Okay, what's important about retained EU law in the new domestic regime? Well, there are three big issues, which is essentially the EU law, EU retained law, takes on a special quality. So in the UK, we have a hierarchy of laws. Don't tell the right-wing media, but nevertheless, we do have a distinct hierarchy of laws now. We have UK law, normal UK legislation and case law, which has a certain status. But alongside it, we have retained EU law, and retained EU law may well be supreme in a clash of norms. And who knows how many clashes we are going to find in the future, because as government passes legislation or as government wishes to use old legislation more, it may often find itself having a clash with retained EU law, and its powers are far greater to bring in new legislation in conflict with retained law than it is to interpret former legislation differently. So the first point is this supremacy of law point. Principle of supremacy of EU law continues to apply on or after IP completion date. That's the 31st of December at 11 PM, the moment of Brexit. Okay, general principles of EU law, they're going to be relevant to the English system going forwards, so long as they were recognised before Brexit, not including the Charter of Fundamental Rights, which was always very controversial. The UK has never been terribly enthusiastic about having rights, and the Charter of Fundamental Rights was one of the first casualties of Brexit. However, query, to what extent are charter principles also general principles of EU law? So, for example, there's a general principle of good administration, which hard-pressed civil servants might often find quite difficult to honour, one imagines. That's recognised as a general principle of EU law as well as being a charter right. In the future, when we read decisions of the Court of Justice, it will be relevant to see to what extent the Court of Justice is drawing on the Charter, because that's something that the UK courts are not going to be too interested in, and to what extent the CJU is drawing on the general principles. That's something that we will be interested in so long as they're pre-December 2020. Okay, also CJU decisions, Court of Justice decisions. So UK courts may have regard to them so far as relevant going forwards. It looks like there'll be, for historic decisions, they look to be part of our retained law, so will be effectively binding, one imagines. But for future decisions, the test is courts may have regard to them so far as is relevant. So the validity, meaning or effect of any retained EU law is to be decided in accordance with retained case law and retained general principles of EU law. So that means that the UK meaning of who is a refugee, which is almost entirely found in regulations and the immigration rules, will continue to be nourished by old Court of Justice decisions, and new ones will have to be looked at with some care. There's amongst the welter of literally thousands of new regulations dealing with Brexit, we have this particular one, which addresses the distinct issue of precedent and the doctrine of stare decisis, as it were. So basically, relevant courts, the appellate courts, can depart from retained EU case law in certain circumstances, but basically they're applying the same test as our Supreme Court would apply when differing from its own decisions, which, to be honest, is a very, very, very conservative approach. Yeah, I mean, our higher court judges only differ from their own decisions where there is a real need for a sea change due to some major development or perhaps a inconsistency amongst the precedents. Okay. Immigration rules in general have to be consistent with the Refugee Convention. So now, just stepping away for a moment from the EU law consequences of Brexit, our rules always have to be consistent with the Refugee Convention. UK is not we're a dualist country, so we don't incorporate international law without taking distinct legislative measures. And so, unfortunately, so that is the only control really on the immigration rules being inconsistent with the Refugee Convention, this general enjoinder that they mustn't be inconsistent. Third country procedures. Yeah, so one major change, obviously, is that the Dublin III regulation is something which the UK is no longer party to. Didn't want to stay part of it, and indeed our political prospects of staying part of it were pretty limited. I think the UK has always seen itself, the government has seen itself as a winner in some ways under the Dublin III regulation, because we're an island and we're at the end of the chain. So you'd have thought we should be returning more people to the continent than the continent sent to us. But in fact, the statistics, I think, probably over time have suggested that because of the amount of migration into the UK generally, the Dublin III regulation, which allows family reunion, has actually allowed almost as many people into the UK under family reunion as were expelled on the third country rules. So, again, maybe the government looks at that and thinks, well, it's not such a loss, Dublin III. These new rules basically tell us that the Home Office will look to see if there's a third country, a safe third country available, where there's a relationship between the asylum seeker and the third country. That relationship could be via the formal recognition of refugee status, or the formal recognition of some other status, or the possibility of protection, as where you could have claimed asylum there but failed to. Broad residual power also to return people, or return is the wrong word, send people to any other safe third country which may agree to their entry. Hugely, wide provision there. The Home Office can send people to any country in the world if that other country agrees to it. Of course, at this moment, law meets politics. and the countries, just as the UK is not enormously enthusiastic about uncontrolled immigration or asylum, especially irregular arrivals, so too other countries are not massively enthusiastic about it either. Okay. Another point, final point I'm going to make is, okay, here's an example of a Court of Justice decision from January 2021, so recent, post-Brexit, looking at the situation in Somalia. And the case is just called Secretary of State for the Home Department. And it's a case where the UK court referred a question to the CJEU, essentially about the extent to which families and clans in Somalia could offer protection, could be seen as offering protection, or perhaps as diminishing persecution risks to an asylum seeker. And there's no doubt that the UK courts historically have thought that they can, as I understand it. But the Court of Justice was quite clear, saying that they fall short of the kind of formal government-controlled protection which the Qualification Directive looks at. So UK decision makers, judges, are going to have to reflect on that a little bit, and may require some reflection on our current approach. So that's the protection is part of the refugee inquiry. So it's going to fall into this EU law test of the retained case law being relevant. This is a post-implementation period decision, a recent one post-Brexit. So courts may have regard to it, not strictly bound by it. And that gives an example. So of legal politics post-Brexit. To what extent are the English judges going to consider that the Court of Justice should be followed where it may clash with some of their own thinking? And there'll be a real test there for them, an intellectual test, and a kind of legal ethical test about where they go, because of course the UK government, the Brexit vote was to take back control, whereas on the other hand, our judiciary have traditionally been very, very loyal. And how do we interpret EU law provisions which are now part of our own law on a retained basis without having very close to regard to what the supranational CJEU has to say about them? Thanks very much. That's all I've got to say on EU law, on refugee law post-Brexit.
Thanks, Mark. Thanks for that sort of timely update on what's been happening in terms of the conversion of refugee law after Brexit has now taken place. For our final presentation, we're going to turn over to Zohra Akhter. Zohra is coming to us from Australia National University. And Zohra's presentation is going to be is titled "When International Refugee Law Becomes Impactful in Practice, Dissecting the Refugee Policy Process." Over to you, Zohra.
Thank you. Can you hear me? Great. I would like to share my PowerPoint slides. So I'm basically going to present my preliminary PhD research findings and the tentative arguments. And if you can see from my slides that the title of my paper is "Can International Refugee Law Be Impactful in Practice?" And this is the outline of my today's presentation. And let me start with the background, why I'm doing this research. Those who are working on the issue of refugees know that Western states' refugee policies has been rapidly changing and taking restrictive turns. And the literature that uses Western states' stringent refugee policies as an analytical tool to understand the capacity of the 1951 Refugee Convention argues that the convention cannot play a meaningful role in protecting the rights of refugees in practice. I basically situate my thesis in this restrictive refugee policy context with an aim to understand the actual impact of the convention on states' policies. My two case study countries, Australia and Canada, that I choose to aid this examination provided the empirical hook for my research. The refugee policy of these two countries is very dynamic in nature and historically fluctuating between restrictive and open refugee policies. Especially after signing the 1951 convention, both of these countries' refugee policies, it seems that took a normative turn. However, in the 21st century, these two countries has started adopting stringent measures. In Australia, it seems that the convention is not very effective in influencing Australia's behavior towards refugees. Whereas in Canada, as it appears, the convention still provides a broader framework for its refugee policy, but the convention encounters hurdles at the implementation stage. And the historical trajectory of Australia and Canada's refugee policies points to an important research puzzle that what explained the varying level of influence of the 1951 Refugee Convention over time and across space. And to unpack this puzzle, my thesis asks the question, why? So this is the puzzle of my, the research question I would like to ask: why, when, and under what conditions the 1951 Refugee Convention influenced the ratifying states' refugee policy and practice. I would like to tell that my method, my research is basically a historical research, and using a policy process lens, I have been examining past 100 years history of Australia and Canada's refugee policies that they adopted since their confederation. And I limit this century-long historical study by focusing on these 6 key policy moments. And by these, my thesis would cover entire period of global refugee governance developed under the League of Nations Human Rights, League of Nations High Commissioner for Refugees and the United Nations High Commissioner for Refugees. Now, let me focus on my research findings. My research findings reveals that there are 6 key policy elements are crucial for the implementation of Refugee Convention in policy and practice. And these are the 6 policy elements: the nature of policy subsystem, particularly whether it is closed only to the traditional iron triangles or open to other actors beyond the iron triangles who are interested in the refugee issues. And the second one is the role of national immigration law. The third one is the role of Supreme Court, and then the role of national interest of the states, particularly the issue of national security, economic interest, and the global image of that particular country. And the fifth one is the role of national identity or culture. And the last one is the role of individual actors. And my thesis shows that the first 3 elements, that means nature of the policy subsystem, the role of national immigration law, and the role of Supreme Court or the immigration law, these 3 elements act as regulative elements of the refugee policy process. And the regulative elements define the regulative rules, which then generates 2 regulative policy conditions that can be varied between closed RPCs and open RPCs in the policy process. And I define in my thesis that regulative rules as standard operating procedures and structure of the policy process. And according to my thesis, the RPCs According to my thesis, the RPCs explains who are the main agents that take part in the policymaking process, what is the legal mechanism of the RPCs, particularly it tells us whether the court of state has the capacity to review and quash a policy decision if the policy does not conform with the regulative rules. Thus, the RPCs determine the relative weight of different policy elements, for instance, national material interest of states, national identity or culture, or the actors vis-a-vis the convention in the policy process. The more the convention gains power, the less the other element enjoy power in regulating the nature of the refugee policy and vice versa. So let me explain how these elements operate with my 2 case study findings. Let me start with my Australian case study. Since its confederation in 1901, Australia's RPCs has predominantly been closed in nature, determined initially by its Immigration Restriction Act 1901 and later Migration Act 1958. Throughout its histories, Prime Minister, Immigration Minister, and immigration bureaucrats enjoy absolute authority over refugee policymaking. The immigration legislature denied courts access to reviewing and quashing policies taken by the government. Thus, Australia's RPCs promoted an actor-dominated conditions. And the historical evidence reveals that the decision of Australian authority to sign the convention and its additional protocol was a pragmatic response where Australia did not want to lose its control over refugee policies to the convention. But they presumed signing the convention would enhance its international reputation, thus helped Australia to overcome the international criticism against its White Australia policy and also help it to ease its domestic labor shortage. Australian policymakers knew that this was only possible by successfully delimiting the power of the convention and privileging its existing Migration Act. Therefore, before signing the convention in 1954, all the department concerned agreed to place reservation on a number of articles of the convention that they thought would jeopardize Australia's policy freedom over refugees. And Australia only signed the convention when UNHCR agreed that Australia could put such reservation on some of articles of the convention. And in 1977, when Australia formulated its refugee policy and mechanism, Australian Immigration Minister formalized the convention as subordinated rules of the Migration Act. And if you look at the four principles of the formal refugee policy, the first two principles of the policy state that, I quote, Australia fully recognizes its humanitarian commitment and responsibility to admit refugees for resettlement. And the second one is the decision to accept refugees must always remain within the government of Australia. So by signing the convention, Australia efficiently developed its new identity called refugee resettlement country and denied the identity of first asylum country. And my research finding shows that convention never ever been transferred as regulative rules for Australia's refugee policy process. But if I look at the Canadian findings, like Australia, Canada's post-Second World War refugee subsystem that was established by its Immigration Act of 1910 was highly closed. And during 1950s, these policymakers thought that the convention would pose a challenge to its immigration program in general and its race-based society. And therefore, they denied to accept the convention in early 1950s. But although, like Australia, the Canadian authority was worried about the implication of various articles, but in 1969, when Canada signed the convention, it adopted a different approach than that of Australia, in which Canada accepted the convention without putting any reservation on any of its articles or provisions. And by 1970s, with the embracement of multiculturalism as national identity, the immigration policy subsystem became relatively open in Canada. And between 1970s and 1980s in Canada, the transformation process of convention as regulative rules took place in this relatively open RPCs. And historical records reveals that when the convention definition of refugee was incorporated in Canada's Immigration Act 1976, it involved intense dialogue between Charge Group, Amnesty International, refugee lawyers, other members of civil society organizations, and members of the immigration bureaucrats. Although immigration bureaucrats actively tried to delimit the influence of convention in its immigration legislature, but because of the strong pressure and criticism of the rights groups, the convention definition of refugee was incorporated in its legislature. And in late 1980s, the power of the convention as regulative rule was intensified in Canadian context as it acquires another layer of legal safeguard. In 1985, the landmark verdict of the Supreme Court of Canada in the case of Symes provided the refugee claimants with the right of oral hearing. As a result, in 1989, Canadian Immigration Authority reformed the RSD, that means Refugee Status Determination System, in line with the principle of non-refoulement. And thus, by ensuring the procedural fairness, and justice, the RSD fulfilled Canada's convention obligation. And that's why Canada's regime became more convention-oriented in 1980s. And based on my entire findings, I would like to argue at the same time conclude here is that whether the convention can be more impactful or less impactful in practice is contingent upon two factors. The first, how it gets translated into the regulative rules of the refugee policy process. And the second is the nature of the refugee policy conditions. So here I would like to stop my presentation, and I would like to hear your any feedback and comments. Thank you very much.
And thank you, Zohra. So we just had three very interesting presentations that really focus. I mean, we've got three very different contexts, obviously. I was interested to hear in the first two presentations. So with Natasha and Mark, the ways that your presentations sort of, I think, in a way addressed a political situation, whether that was gender politics in a country of origin, in your case, Natasha, or of course, Brexit, which is a political event in many ways, Mark, and looking at the ways that refugee law is or could respond and adapt to those political conditions. Zohra, your presentation sort of approached this from the other direction, which was to look at the ways that the political conditions actually shape the development of refugee instruments, or the ways that refugee law is interpreted and implemented in Australia and Canada. So I welcome, I found this very interesting. This is actually sort of leading into one of the questions that I would like to ask all of you. And I'll just also say that for everyone else out there, to please continue posting your questions in the box. And I'm seeing some questions come in, but as chair, I will take the privilege of asking the first question. And this would be sort of drawing on Zohra's presentation. I would direct this at Natasha and Mark, and I would be asking, and I also welcome you, Zohra, to respond as well if you have views on this. It would be to ask, in your cases, when looking at, for example, Sudan and countries to which refugees and refugee women from Sudan have fled, and specifically from Darfur, what would be in that case, what would you say are some of the ways that political conditions or the political climate, be that at an international level among funding countries and the UNHCR and the countries that fund the UNHCR, or locally, to what degree has that influenced choices about whether to try to push for repatriation in some cases, which, as you've indicated, may not always be voluntary? And Mark, similarly for you, I would ask, to what degree within the UK has political climate, the political conditions here, actually shaped, in your view, the ways that these changes post-Brexit have been made? So I would turn over maybe first to Natasha with that question. I think you're still muted, Natasha.
All right. Thank you so much for the question, Cory. I think it's really at the crux of the issue because where international refugee law and the conditions around return are not very clearly spelled out in law, and at the moment, voluntary repatriation is not adequately dealt with in the 1951 Refugee Convention as it is in African law, then the danger is that it's completely overtaken by political interests. So that means that a voluntary repatriation process is less likely to be about women's rights and much more likely to be about understandable pressures in country of asylum for individuals to return, and importantly then donor states to withdraw funding and have also fatigue for continuing to support refugees for what's been 2 decades now, up to 2 decades in countries of asylum. So they will then create a push factor, and if that's the case, then and that's the flavour of many of the voluntary repatriation so-called exercises that you have seen historically, and whether it's the interests of states then that will prevail. Then, from a feminist legal theory perspective, then is it the role of the state to decide when and how women will make those decisions? And is there any agency for women at all? That'll be the question that I would be asking. And that's why feminist legal theory is such a useful lens to through which to analyse it.
And over to Mark.
Yeah, sure. I mean, so repatriation and the UK, it's not really been something that's been massively on the UK's agenda, though it has been spoken about in recent years. For example, the UK's attitude tends to be that it has enough of a problem making decisions and getting the appeals dealt with. We have a quite an elaborate appeals process for first-time asylum seekers and dealing with other refused cases more than revisiting the situation of people who've actually been granted status. There has been, obviously in theory, the Refugee Convention only envisages temporary protection, doesn't it? So the Refugee Convention, you might say, it's not intended necessarily to be an integrative or measure that necessarily brings settlement with it. But of course, human life being that's what it is, that's how it's been seen in practice. The UK government does offer resettlement packages of several £1,000s, and if people take that up, then that would be held against them were they ever to return to the UK and try and maintain some kind of human rights claim here. Yeah, thanks.
Thanks both. Zohra, did you have anything to add to that, or no worries if not, as that was largely directed at Natasha and Mark?
I would just like to add some perspective about your question on the closed and open subsystem. I just would like to, from my findings, what I can see that there is this geopolitical positioning or the proximity from where refugees are fleeing. It doesn't have any influence on the policy subsystem, because if you look at the Australian policy subsystem, the formative period, that means when Australia was formalizing its policy subsystem, there was no such kind of refugee pressure on Australia during the Cold War period, especially after 1950 Convention was adopted by international community. And Australia was pretty much aware that, had that confidence that Australia was geographically geographically has a positive position that's safe from other countries where refugees are fleeing. So, and that's why Australia accepted the convention when even in 1967, when the convention definition was universalized. Australia had the confidence that there would be no that kind of first asylum flow in the context of Australia. So I don't think that this proximity has a kind of influence in this formation of the policy subsystem. It's a kind of a bureaucratic setup, and how the policymakers, the key policymakers, how they formulate these refugee policy conditions, and how the other non-state like civil society organizations and the activist groups, rights groups are very vocal in this refugee policy making environment, how their voice is being very effective in this policy making area. These all things are playing very dynamic role, but not the geographical issues have a very good element in formation of this subsystem.
Thanks for that, Zohra, and thanks, Mark and Natasha as well. I've got, I'm just turning now to the chat, and I've got a few questions here that are aimed at particular individuals, but of course, if anyone else wants to respond to the issue that's brought up, please do. For Mark, we have a question from Nick. In terms of Dublin 3, could you talk a little bit more about how you see this playing out in the long term in terms of politics in the UK and the EU? Equally, the idea that the UK is going to benefit from EU externalization policies without contributing to it. Nick points out, sorry if that is obvious. but I think that would be, I think that's a good question. We can also, there's another question I have here for Zohra. And that is, this is coming from Natasha, actually. So thanks, Natasha. Zohra, thanks for presenting interesting research. I wonder whether refugee policymaking in Canada or Australia has meaningfully incorporated views or civil society, views on civil society or refugees, for example, through community consultation processes. So maybe I could first turn over to Mark in regard to Nick's question.
Yeah, sure. So, I mean, obviously, we'll have to see how this particular aspect of the post-Brexit political arena actually plays out. I suppose one reason why the UK was keen not to be caught up in Dublin anymore was that Dublin 4 is on the horizon, and though Dublin 4, as I understand it, probably contains less procedural protection for asylum seekers than some parts of Dublin 3, it does so in the context of increased burden sharing between states. And obviously the UK's domestic political discourse is antagonistic towards participating in increased burden sharing. Even relatively modest little bits of burden sharing, like the taking of asylum seeking children, haven't lived up to original expectations. So there was a legislative provision that was christened the Dubs provision after its sponsor. And the idea was that that was going to allow a certain amount of asylum seeking children with only modest, if any, UK connections to be brought to the UK each year. And surprisingly, it transpired that the local authorities seemed to have more appetite for that measure than did central government, which didn't provide them with anything like the cases to fill the available capacity. So there's not, so it doesn't seem a lot of enthusiasm for burden sharing going forward. I mean, in terms of the EU externalization policy, I understand that to refer to things like the deal with Turkey to keep asylum seekers there. I mean, it's true, isn't it? The UK as an island obviously benefits from not only from its own externalization policy of keeping a stiff border, but also anyone else who stops refugees coming here, no doubt the government is happy to take the benefit of that. Where any of this leaves us in terms of future negotiations with the European Union, we'll have to see. Will the European Union suggest that the UK should show greater enthusiasm for asylum seekers if it wants to sell its mollusks, to France and Belgium? We'll have to see how that pans out in practice, won't we? Thanks.
And thanks, Mark. Zohra, do you have a response to this question?
Yes, to Natasha, you would like to know that the community consultation in the policy making process for Australia, there is no community consultation. No. Their policy making is very closed. It's just within the cabinet. They sometimes present their policy in the parliament. But this is a very interesting findings from my research, is that because I also had the research on the parliamentary debates. It's a very interesting thing that there's a very strong bipartisan support for the Australian refugee policies. It's historically, it receives always a bipartisan support. And if you look at the public referendum in the parliament, there is no such kind of public referendum in Australian parliament, at least till 1980s. Because as I covered the policy moments, I look at the particular policy time period and the parliamentary debates during that time period. So in Australian context, there is no that kind of community consultation. Sometimes the immigration minister, if they make some policy, they just make some press statement. They may make the press release, that's it, that's all. And for the Canadian context, I just would like to inform you that I haven't completed my the recent research on the recent policy changes. So I have completed till 1980s. So based on that findings, Canada, there is a strong community consultation. Even the Canadian government, when they they incorporate the convention in the legislature. Especially they form the refugee determination system. They involve a very effective community consultation in various ways. And it is the evidence that church group played a very key role, and they act as a very strong pressure group for Australian case. And whatever the policies now we can change in 1980s, that in that policies, the civil society organizations, refugee lawyers, and the church group, they played a very, very effective and strong role. So in Canadian context in 1980s and 1980 till 1990s, there is a strong voice of the community consultation. And there are different kinds of policies proposed by the immigration bureaucrats, such as the safe third country provision or this kind of restrictive measures. They introduced it, but they cannot implement because of these right groups, because whatever the thing is going on, they pick up the issue, they take it to the court, and then court give the decision. So this kind of situation is going on in Canada, but Australia, this is not the situation. So there is a difference between Canada and Australian context.
Thanks for that, Zohra. And with that, actually, can I think sort of two questions for Natasha, and I would just maybe turn one over to you. Would just be, I'm just curious where the question is coming from. So, if you had some views on community consultation that sort of sparked that question. The second question is coming from listeners, and so that the question here is from Atikula Syed, and this question is: the UK voluntary return scheme is everything but voluntary. Restriction of rights, hostility, and risk of deportation leave no other option for failed refugee applicants but to leave. Plus, most VRS applicants are incentivized, which defeats the purpose. In absence of a supervisory body for the Refugee Convention, how could this coercive practice be challenged when failed asylum seekers are already their appeals rights are already exhausted? And maybe this could be a question that could also then be extended to Mark as well. But Natasha, if you'd like to maybe address both of those issues to start.
Thank you again, Cory. I was just very interested in Zohra's presentation because I have had experience with community consultation in Australia, both on refugee status determination and resettlement over the past once 10 years ago and once a couple of years ago, and was able to compare that consultation over time. So I was just interested to hear your perspective on how you thought that it influenced policy making, and whether Canada has a different system where views of both civil society and refugees can be meaningfully incorporated. And I think you've answered that really well. So that's super interesting. Thanks. As for the question from Atikala, thanks. It's an excellent question. And it gets to the crux of the issue. From a moral and philosophical point of view, there are arguments to be made, as I did in my presentation, that a decision can't be considered voluntary where there's no other choice. And this is even more the case where a failed asylum seeker, as you're saying, is experiencing a violation of their rights in the country where they've sought asylum, and can also be significantly harmed as a result of that. So, I'm thinking of the analogous situation of so-called failed asylum seekers in Manus Island, and how significantly they've been harmed from detention and various other experiences in Australian offshore processing centres, and how then it would be difficult to ever, envisage a return that could be considered voluntary in those circumstances, or anything but forced. And where, if so-called failed asylum seekers have been significantly harmed as a result of restrictive asylum policies, then there may be a situation where they don't meet the refugee definition, but should be given complementary protection. And failing all of that, you know, this is why I drew attention as well to the policies and practice of New Zealand, where I do think a very different thinking around or approach to international law is taking place. And it really is, you know, what Carol Gilligan was talking about is an ethics of care approach that, you know, turns away from, you know, liberalism and notions of justice and law and is purely based on humanitarianism. So, you know, in offering to take some of those people who have been really harmed from Australia's offshore processing. Yeah. So even though it's separate from, you know, the already existing laws and policies and refugee quotas, so it really is an ethics of care approach and one that could be emulated elsewhere. So, thanks again for the question.
And just to ask Mark, do you have anything? I know that question was sort of directed at Natasha, but of course it's focused on the UK. Just wondering if you have anything to add on that. You have already briefly discussed the issue of repatriation, but specifically in regard to this this viewpoint.
Yeah, sure. I mean, here the repatriation question is different, really, isn't it? In the sense that the previous question was about the return of people recognised as deserving of international protection once their needs were perceived as expired, whereas this question is more about is about failed asylum seekers, isn't it? And I suppose one point to make at the outset, I suppose, is that the system to be politically acceptable or, you know, intellectually coherent, it has to admit of the possibility of people going back to their own countries if they are failed asylum seekers. Otherwise, the whole system, the system breaks down. If you can't, if the non-genuine people don't go back, then, you know, very hard to maintain any integrity to the Refugee Convention. However, there's some side issues. You know, one is procedural integrity, and so it's important to have status determination systems that are right first time. Something which we struggle with in the UK. Without, you know, we have an appeal system which allows 50% of appeals in asylum cases. I'm told, you know, which suggests, you know, that there's work to be done at the Home Office in terms of speedier identification of who is a refugee. Many people put in fresh claims for asylum after their original claim has failed. And although a lot of those are frankly hopeless, some are inducibly genuine, and that often because they've been let down by the community advisors, legal advisors, or whoever. Where we have people who, you know, are facing return, and they are genuinely at the end of the system, and there should be no further encouragement of claims, there's still issues about, you know, making a return that is, you know, suitably respects their human dignity. And the Home Office has to be realistic about when it can remove people. It seems, you know, we have a real problem in the UK in detention centres. Many people are detained for lengthy periods. I mean, sometimes in excess of 4 years, where it's hard to detect a lot of progress in their return, you know, and these will nearly always be foreign criminals, as they're so labelled. They're people whose criminal record makes them as unappetizing to their own country, it seems, as they are to the UK's authorities. But ultimately, I mean, if people can't be returned, they need to be given some kind of temporary immigration status rather than, you know, have them detained at enormous public expense and often involving huge damage to their mental health, none of which helps their rehabilitation wherever they're going to live in the future. Thanks.
Thanks, Mark. We have a few more questions coming in. We have one from Christina Olgemoller, and that is directed to Natasha. We keep talking about refugees as if they are non-gendered. Mostly we victimize women and turn men into scary threats. So what would an ethics of care for abused men look like, in your view? And this actually a second question for Natasha as well. And of course, others can jump in if they have something to contribute to this. And this is coming from Nick. Really interesting in regard, a similar question about the ethics of care in the humanitarian approach. Is there a risk that this approach is inherently short-term or temporary? And maybe actually, if Nick, if you could clarify in what regard you mean that that ethics of care would be temporary, in the sense that care is referring perhaps to a humanitarian approach, which is of course temporary and short term, versus longer term. But Natasha, if you want, you could go ahead and if you wanted to start with the response to Christina's question.
Yeah, I'll just quickly just dovetail off what Mark was saying before as well, and about the integrity of asylum systems and the need for failed asylum seekers to be returned, you know, within the context of international human rights law and so on. That goes without saying. I think I was talking about quite a particular circumstance where people have been in very long-term detention or quite significantly harmed as a result of those conditions. So that was more of an exception rather than the rule that I was addressing before. And otherwise, I agree with you, Mark. So Christina, thank you so much for bringing up that point. I'd hope someone would do that, because couldn't really go into detail in the presentation about the importance to focus on different categories of refugees and take an intersectional approach to the needs of not just women, but you know, LGBTI claims, or you know, men who have particular needs as well. And so, I mean, they're very much linked issues, and the point is to approach solutions on the basis of need and be driven by protection concerns. And I think that's what the ethics of care approach is about. And certainly all of the men that I mentioned who are on Manus are men, of course, and not scary and not threats, but certainly have been harmed by restrictive policies and are therefore in need of a solution on a humanitarian basis, and that's what New Zealand is offering. So thanks for bringing that out, and I don't think an emphasis on the needs of women should you know, devalue in any way the needs of men or other groups, the contrary. And then Nick. Doesn't suggest temporary human rights responses rather than long-term legal responses. So yeah, so I think that the approach that what I'm talking about is more just an approach to the law. So because I was talking about third states and there's an absence of any you know, obligation to you know, binding law to cooperate to find solutions, then what's the, you know, moral or legal basis for states to cooperate? And in this sense, you know, Carol Gilligan is saying, well, you know, there's a humanitarian imperative, and that's based on a completely different way of thinking about the law and international refugee law and what its purpose is. And, you know, instead of focusing on the interests of states within that system, it would focus on the individuals within that. So that's hopefully not oversimplifying it, but when you're talking then about, you know, solutions, you're talking about durable solutions from an ethics of care approach that's from a humanitarian approach and not driven by political interests of states alone, which, you know, is more and more the case. And there's evidence, I think, quite a few good articles at the moment about different resettlement programs being driven less by need or protection concerns and more about political interests. So there's quite a bit been written on that recently. So that's what I'm talking about countering.
Mark and Zohra, do you have anything to add to those comments from your own perspectives? Nothing there. We do have another. Nick says thank you. We have another question also directed at Natasha, just building on that last point, I think, from Helia Lopez Zarzosa, and that is asking a different dimension, referring to a different dimension on the gender issue, motherhood and return. So just a general question, do you have any thoughts based on your expertise on this area, motherhood and return?
Because I can only really see from where I'm standing, I've just seen quite a bit of separation of families. So as a designed, you know, package of punitive measures for people who arrive by sea. So, you know, first and foremost, I would think that, you know, the right to family unity should be first and foremost in any return operation. and that, you know, especially immediate family should not be separated, which unfortunately we've seen in Australia for various reasons. And otherwise, motherhood and return. Yeah, I mean, if motherhood creates a particular category or need, then of course it would be consistent with you know, prioritising that in the solutions process. I'm not sure that I've adequately addressed what you were thinking, but I'm happy to discuss further offline.
Thanks, Natasha, and thanks for taking sort of a series of quick, rapid succession questions. I'm not seeing any more questions in the chat at this point, so I think we're probably able to wrap up. I might ask if any of the panelists had any final comments, and maybe also looking at, I mean, one thing that would be interesting to hear very briefly is maybe where you're looking to, you know, to take your research that you've presented at this point. If you're working on a publication, or if you're looking to extend it. I know, Zohra, you already mentioned that you're continuing to do with your work to look beyond the 1980s. Also would be curious to know, for example, whether you're looking to expand the framework that you're using to looking at other countries, such as perhaps the United Kingdom or other target resettlement countries. But I would just turn it over, and maybe we could keep it to, like, if you do have any final comments, maybe keep it to something like 2 minutes, and then we'll be able to wrap up. So maybe turning it over, I'll come back to you, Natasha, since you just finished. I'll turn to Mark first and ask if you have any final wrap-up comments.
I see one question. I see a question was in the chat now that I don't think we'd alighted on, about how the Secretary of State is said to be giving expansive interpretation to the phrase "coming directly" in Article 31 of the Refugee Convention. And I guess that crops up in two bits of our law. One bit is third country returns, where it may be a test in terms of the connectivity between the asylum seeker and a third country. And I suppose it might also come up in the context of criminalisation of your immigration journey to the UK, because that coming directly phrase is part of the defence in Article 31 of the Refugee Convention against criminal sanction, in that recognised refugees shouldn't be treated as criminals based on if they have come directly from their country of origin. Insofar as the latter question arises, coming directly has been interpreted by the UK courts, and so the Home Office shouldn't try and undercut that unless they have legislative backup with parliamentary authority, which I don't believe they do. So there's an easy answer to that. If they use it as a connectivity test vis-a-vis third country returns, well, one would have to think about that. The Refugee Convention doesn't use it, doesn't necessarily use the term in relation to third country returns, because of course the Refugee Convention doesn't deal with third country returns explicitly at all, but it's not incompatible with them, hence the whole apparatus of third country return, which every nation state has sort of signed up to. So we'll have to see how that develops in UK law. Thanks.
Thanks, Mark. Over to you, Zohra. Any final comments?
Yes, Cory. Yes, I have a plan to do this kind of research to other Western states, particularly because when I do my literature review, I found that when the literature that focus on the international law implementation and international refugee law implementation in specifically, I see that so far I haven't found any research that focus on the policy process, especially how the international human rights law implemented through the policy process. And where my research, I feel like that's the unique contribution would be of my research, that I'm basically examining the policy making processes. So I have started initially with my PhD studies between Australia and Canada, but I would like to extend this research to European countries, because in Europe, the institutionalization of the convention is I think that there are better institutionalization. And after Mark's presentation, I feel like, yes, there are some kind of incorporation of the convention in Australian, in UK's legislature as well. So that makes me particularly interested in how these countries, how the convention is being implemented through their legislative process. At the same time, I have covered only the Canada, but I'm very much interested about American United States, how this process is going on. So yes, for my postdoc, I have a plan to like expand this kind of thing, and I would like to see the framework I'm going to develop, how they are, how these things are have kind of understanding from the other countries' perspectives. Yes.
Thanks, Zohra, and we'll be looking forward to seeing how that research develops. So best of luck as you take that into a postdoc. And finally, Natasha, back to you for your final comments.
I have nothing further to say, just thanks to my fellow panelists, to Mark and to Zohra for exercising my mind at this time of night with really interesting and thought-provoking presentations, and to Cory for pulling it all together, 3 diverse topics and pulling them together. So thanks to people who were listening and engaging. Thanks. Appreciate it.
Thanks, Natasha, and thanks to all of you for presenting your work, and thanks to the listeners for bringing their questions to this. We're quitting with just 3 extra minutes to get your coffee together before we start the plenary. So with that, thanks everyone, and looking forward to seeing you all at other events for the final day of the conference. So thanks everyone.